Springboard injunctions started actually outside the employment context, but it was always in relation to confidential information. So the concept being that he who takes the confidential information should not use that as a springboard or a jumpstart over the person that you took the information from in order to gain an advantage. So when brought over to the employment context, then it became a matter of your ex-employee should not be taking the company's information and then starting out his own thing and gaining a head start on the employer because of that. So the employer, of course, would want a springboard injunction to prevent the employee from taking advantage of their information to harm them. JLT case was quite interesting. It was employer against its employees as well as the prospective new employer of the employees. And they sought 4 injunctions, 2 of which were springboard injunctions to prevent the employees from joining the new competitor, as well as to prevent the competitor from hiring them. That was the springboard aspect of it. The others were just injunctions to stop them from using the information. In the course of submissions, what came out was that there are sort of 2 diverging routes. In the UK, they've been more liberal in the application of springboard injunctions. They've put it out even beyond confidential information situations and extended it, and they're also more liberal in granting springboard injunctions. On the other hand, you have Hong Kong and Australia where they're a little bit more conservative, and they've decided to limit it just to confidential information and not wider than that. And also, there needs to be strong evidence of misuse of information or a great risk of misuse. So on the particular facts for this case, the JLT case, it was held that there wasn't enough information to grant the springboard injunctions. The comment that the judge made was that it's made in very extreme circumstances, and based on the facts, the extreme circumstances weren't there. So although the employees had been found to have passed around a top clients sort of list, that was not enough to cross the threshold to grant a springboard injunction. What is needed is apparently more evidence of misuse of confidential information, and then perhaps the court will consider granting one. So in this case, they didn't manage to get one.